In Pennsylvania, what are my rights if my name is on the deed but not on the mortgage? I'm Lee Schwartz. I'm the founding member of my law firm, Schwartz, Fox & Saltzman in Philadelphia, and I've been practicing family law for 43 years. What happens if your spouse is not on the mortgage after the divorce is finalized? It really doesn't matter all that much because the economics of that property are going to be resolved, and either one party is going to keep the home and pay off the other party for their percentage of interest in the value of the property, or the house is just going to be sold and the mortgage is going to be paid off. So it really doesn't matter. So what are the implications of a person's name being on the deed but not the mortgage? There really aren't any implications. Being on the mortgage just defines who repays the loan. It really doesn't impact us in divorce. What happens if your name is on the mortgage but it's not on the deed? And the answer is it depends on whether the property was purchased before the date of marriage or after the date of marriage. Before the date of marriage, if your spouse owned a property and of course your name was not on the deed, your spouse has the right to keep all the value up until the date of marriage. However, regardless of whether your name is on the deed, you get a portion of the increase in value of the property during the marriage. After marriage, many times parties buy real property in the name of one spouse. That doesn't matter either, because the titling of property in Pennsylvania that's bought after date of marriage is irrelevant. Everything acquired after date of marriage in Pennsylvania is marital property, regardless of how it's titled. If you want to learn more about divorce in Pennsylvania, be sure to subscribe.